10 years ago, if you went in to purchase a firearm and they ran your NICS background check and it came back that you had been convicted of misdemeanor assault.
No mention of domestic violence, no mention of family violence.
No mention. Fine. Ding, green light, proceed, buy that firearm. Today, completely different story, because now when the FBI sees you've been convicted of misdemeanor assault, they're sort of, we call it going behind the curtain, right? That's when we talk about it just colloquially around the office. They're pulling that curtain back to say, who was the victim?
Yep.
So even though your charge doesn't actually read family violence or domestic violence, the FBI is often investigating and pulling those documents and asking, or just simply denying you and telling you to prove that it wasn't a spouse or someone similarly situated, it wasn't a crime of family violence before you have the right to purchase your gun.
Right.
It is really, really, I think, tough on people who, particularly, let's say, they've been buying guns for ages and ages and ages.
Right.
All of a sudden, they're getting denied, and they want to appeal it, and they want to challenge it. And when we look at the crime and we say, oh boy, well, that was against the woman you were living with back in 2004, there's really no challenge to be had here other than resolving your record, which we could talk about later. I think that's a question that's already come in.
Yeah.
I mean, it's tough for people to hear that.
Yeah, and that comes up, think even worse than 2004. Go back before the Brady Handgun Violence Against Women Act, how are you want to categorize it? And this question comes up.
Well, John asks.
Okay, let's hear it.
If a person had domestic violence over 2 decades ago, no other crimes on his or her record, can they buy a firearm? And if not, why? And if not, how can they get their rights restored? So there's a lot of good questions in there.
Yes.
But let's talk about, Brady was passed in 93.
Yep.
Correct? So what happens if you were convicted of domestic violence before 1993 when this wasn't the law?
Right. And I'll answer, there's kind of two caveats to this, because I know a lot of folks will say, hey, that law was ruled unconstitutional by the Supreme Court. Congress reauthorized it. Mm-hmm. And what they did is they added some findings of fact and conclusions of law that basically cut the court off. And so that is the law of the land right now. And then the second question we get of, that sounds ex post facto.
Doesn't it, though?
Yeah.
Unfortunately.
So 1993, let's say the conviction was before 1993. Why? That wasn't the law of the land at the time that I entered this plea. Why should it be held against me? And the answer is...
because the courts say that it can be.
Yeah, the courts say that it can be. And
Yeah.
they say it's not ex post facto, therefore it's not ex post facto. And so if you have one of these old convictions, it is going to be a disqualification.
Yes.
Like we said.
Even decades ago. Even with a clean record afterwards. Now, that is assuming your state doesn't have some sort of mechanism by which charges are automatically dropped, expunged, and all of your civil rights and firearms rights restored.
First offender.
Exactly. Some states have that. It's great. That is not the majority of states.
No.
The majority of states, if you're convicted, you are always convicted until and unless you take those affirmative steps to clear your record.